Hello, my name is Teneille Brown, and I'm going to talk with you today about an immunity provision that was passed into law last spring. It was Senate Bill 3007, and it was signed by the governor on May 4th. And what this provision did was it provided immunity for personal injury lawsuits if someone contracted the coronavirus or COVID-19 on the premises of that business. So it could be for employees, it could be for the public who maybe come in and enter the business, but it excludes from the immunity any conduct that is considered willful misconduct, so more intentional misconduct, or reckless infliction of harm. But it does block gross negligence or negligence lawsuits. So there are already prima facie elements built into negligence: duty, breach, causation, and injury. Causation would always be difficult to prove in a case like this. Even without the immunity provision, a plaintiff would have a hard time proving that they probably contracted the SARS-CoV-2 virus on the premises. The defendant could always say, no, you got it from your kids who were going to school. So there's already a built-in hurdle for proving a negligent transmission of an infectious disease in a case like this. However, the bill's sponsor, who was Kirk Cullimore, who's from Draper, he said at the time it will make it easier for businesses to open their doors without fear of frivolous lawsuits. And of course, frivolous lawsuits are a bad thing. They're inefficient. They're a waste of time. But this statute goes much further and actually prevents plaintiffs from bringing legitimate, valid negligence and gross negligence claims. So there is a provision that you may be aware of the Utah Constitution. It's Section 11. It's called the Open Courts Provision. And what it does is it says that the legislature cannot take away from private citizens the right or remedy to access the courts to get redress. And some of the reasons behind this provision of the Constitution and some of the arguments in support of it in recent case law suggest that what the legislature did here with this immunity provision is exactly the kind of thing that would not be allowed by Section 11. Namely, what it does is allow powerful businesses or enterprises to lobby the government to get a law passed that protects them from being accountable to private citizens or to ordinary people. And the worry is that you've got the courts that can protect the kind of poor, ordinary, not very powerful individuals. But if you strip away from them the right to access the courts through some legislative action, then it's going to run against the Utah Constitution and the access to the courts provision. So that seems to be what's happening here. And I think it's very likely that if someone with standing were to challenge this immunity provision on Utah constitutional grounds, they would very likely succeed. The problem, of course, is that if you contracted the coronavirus on someone's premises and you were thinking of bringing, say, a wrongful death action, then you would first have to challenge the constitutionality. And so that's going to be a very resource intensive and kind of steep hill that you're going to have to overcome. It's going to be very expensive. And that may be why the legislature passed this immunity provision, was to stimulate the economy, get things opening up again. But it really did so by putting the cost and the risk of opening back up on the backs of private individuals who may not have access to enough information to evaluate the risk. Normally, we put liability on defendants if they're careless, thinking that they can survey their businesses, figure out where the risks are, and better protect not just their employees, but the public. But here, we're assuming that private citizens are going to somehow have access to better information about whether or not they should go out to eat at a restaurant or show up for work. And especially when we're talking about employment conditions, there's much less choice and much less freedom to just say, oh, well, now I'm not sure if my warehouse is taking adequate precautions, therefore I'm just going to find another job. That's obviously pretty tricky and pretty difficult for individuals. So let's take a concrete case and apply it here. We don't have to invent one. There was a case of an individual who worked for Sportsman's Warehouse. His family thinks that he acquired the coronavirus at work. His claim was that there was an outbreak at work. This was in the mid-spring when there was very little community spread in Utah, and they think that that's where he contracted it because he wasn't going anywhere else. There was a known outbreak at the time at the warehouse. The claim in the complaint was that the defendant was careless, they weren't checking temperatures, they weren't isolating people, they weren't making sure that there was social distancing and mask wearing and so forth. But the the plaintiff's complaint maybe didn't understand or appreciate that there was this immunity provision. And so the response would be, this is negligence. Unless this amounts to willful misconduct, which it likely did not, then it would be blocked by this immunity statute. And so in this case, you may have had clear, depending on the way the facts developed, you may have had negligence. Let's assume for the purpose of this conversation it was negligent. The family would not be able to recover without first proving that this statute is unconstitutional under the Utah Constitution. So we may really like the idea of stimulating the economy, getting people back in work, opening schools. That may all be a good argument from a kind of policy perspective, but the Utah Constitution makes it clear that we can't make those trade-offs in favor of powerful, wealthy corporations and take away private individuals' access to the courts. So we'll see where this goes. We'll see how this case carries forward and if they do try to challenge the constitutionality of the provision. But there's almost a sense that even if it's proved unconstitutional, if it just deters legitimate negligence cases because people don't want to mount that constitutional challenge, then in some ways it will be effective because it will reduce the number of lawsuits. The problem here, of course, is that it puts the risk in the wrong place, and that employers and a restaurant should be required to keep up reasonable standards of reducing transmission of the virus. If they're not having adequate ventilation, if they're not ensuring that their cooks are wearing masks, they're not wearing them around their chins, as many of us have seen, if they're not making sure that they're washing their hands or providing them with hand sanitizer, and then someone who goes into that restaurant contracts SARS-CoV-2, then that doesn't seem like the right allocation of risk, because they have much better access to information about how to reduce transmission as compared to, say, a private individual or an employee who doesn't have the capacity to correct those kind of risky things. So in my view, this is a very bad statute. If we want to encourage opening the economy, what we ought to then do is maybe have strict public health regulations that are monitored and enforced with surveillance teams, rather than saying, well, we're going to open the economy, and if anything bad happens, we're going to put all of the cost and risk of that on private individuals. So if you have any more questions about this, I'd be happy to talk about it further. My email is teneille.brown@law.utah.edu, and that's Teneille. Thanks a lot. Hope you have a great day.